Next up on This Week in Law, we've got Polk Wagner, Julie Ahrens, Evan Brown, and me. Holy Prenda, we're going to look at the sanctions order in that case and wonder about whether Paramount has some sort of product placement going on. We're also going to look at Washington looking at technology, a whole bunch of pending legislation that could be good or bad. We'll try and figure out which. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 210, recorded May 10, 2013. Into the Prenda Darknet. This episode of This Week in Law is brought to you by ProXPN. ProXPN is a virtual private network that allows you to use the internet the way it should be, anonymously and without oversight. For 20% off your new account, go to proxpn.com/twit and use the code TWILL. And by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter TWILL. Hello, you've joined us for This Week in Law. I'm Denise Howell, and oh my goodness, there's so much going on this week. We have some really fun stuff to discuss and some great people to discuss it with. We have Professor Polk Wagner from UPenn Law School. Hello, Polk.
Hi, how are you? Thanks for having me on.
Doing great. It's our pleasure. We're so glad you could join us. Also joining us from Stanford's Center for Internet and Society and its Fair Use Documentary Film Project is Julie Ahrens. Hello, Julie.
Hi. Thanks for having me. Glad to be here.
Let me check. Am I pronouncing your last name correctly?
Julie Ahrens. Yep, that's right.
Ahrens. Right on. All right. And joining us from Chicago, Illinois, and the Info Law Group is Evan Brown. Hi, Evan.
Good afternoon, Denise. It's good to see you. Looking forward to our conversation.
Me too. And there is just a ton of stuff to get to, some really entertaining stuff as well. So let's start right out with some things on the copyright front. All right, well, we've talked a bit about the various Prenda lawsuits on the show before. Specifically suits that have gotten the attention of judges as to whether or not they should have been filed, whether or not parties were doing the right things. And Judge Wright in California has recently considered and decided that, in fact, a whopping big sanctions order was justified. That came down this week. And I'm just wondering how on earth Paramount Pictures managed to get their Into the Darkness product placement into this judicial sanctions order. It's something I've never seen before, but the thing is laden with Star Trek references. Evan, first of all, this judge was really ticked off, wasn't he?
He sure was. And, you know, it's something that we could see coming. This has been covered pretty well in the last few weeks. Ars Technica, especially our friend Joe Mullen over there, has covered this latest chapter in the Prenda Law copyright troll BitTorrent plaintiff saga. So the kind of the foundation for this is, this was one of the run-of-the-mill copyright infringement lawsuits going on, and Judge Wright in it's the Northern District of California, right? Was kind of started recognizing that something wasn't quite right with the Prenda Law's business practices, and ordered that the attorneys show up and answer a few questions. A few weeks ago at least, they did, and took the Fifth Amendment, when questioned about, some basic things like who owns this company, who's the plaintiff here. And so Judge Wright has issued this order sanctioning the Prenda lawyers for, to the tune of $80,000 and the other side's attorney's fees, adding, putting a multiplier on that as well. and saying that my favorite line was talking about how he finds that the lawyers have a form of moral turpitude that doesn't make them fit for the practice of law, or to be an officer of the court, or something like that. Moral turpitude is the key the key term there. So Judge Wright is not happy, and this is just the latest chapter in what many of us who have been involved in these types of cases, these copyright trolling cases, are actually watching with a great amount of delight, seeing how Prenda's lawyers and its tactics are really being the light of truth is being shown upon them, and the demonstrating of how what they're doing really is not the way things ought to be done. So, Star Trek references and all, I'll leave it you to parse those, Denise. It's an entertaining read.
Well, there's definitely quite a few of them in there. Joe Patrice over at Above the Law has got a full aggregation of them if you want to see them called out of the opinion. It opens with a quote from Wrath of Khan and closes by saying that the only enterprise that these plaintiffs resemble is RICO, which is the federal racketeering statute. So the judge was clearly having some fun here, and also wanting to send a very clear message that he was not pleased with the way that these plaintiffs were playing around with the court. Polk, were you surprised about this at all?
So I don't think that anyone should be surprised that Judge Wright was pretty upset by the various tactics. I mean, if you follow the various permutations of what's gone on there, it's really just an unbelievable story of confusion about who the lawyers are and who they're actually representing, and there's allegations that they made up a person in order to file the lawsuit, and there's just, it's almost unbelievable. You couldn't write a movie or a story that would be any more crazy than what's gone on here. That said, I think that to some degree, I think Judge Wright in using sort of all of the Star Trek references and things, in a sense, sort of underplays and makes light of what is a really serious issue, which is, in this online environment, you need to have certain standards for when you can file a lawsuit against somebody for, in this case, copyright infringement. And I think, we've gone through some of these before in terms of the record labels and their infringement lawsuits against downloaders, and found that, IP addresses are not enough. You need to have more information than that. You can't simply send out blanket sort of John Doe lawsuits and expect to get recovery from a court. And the courts are going to be quite aggressive about enforcing certain standards for lawyers in this context. And so I think that I sort of wish that Judge Wright had not used as many Star Trek references, and had been, even more clear that this is, what was going on here is just simply not appropriate for litigation, especially in this day and age when it's so easy to find out somebody's IP address who's on, for example, a BitTorrent network, and at that point, file a lawsuit against them, which is essentially what these plaintiffs were doing.
Julie, do you think that the fact that their tactic here, the plaintiff's tactic, was to try and embarrass people for their pornography downloading tendencies, do you think that factored into the harshness of this sanctions order?
Sure. The judge has this sentence, the nexus of antiquated copyright laws, paralyzing social stigma, and unaffordable defense costs allowed, the plaintiffs here to plunder the citizenry, as the judge put it. And I think that the shame there is a big factor. I think the other really important thing, and obviously an important factor in the judge's decision here to see what was motivating these plaintiffs was not actually anything related to the copyright or the protection of their intellectual property. It was to use this leverage to get unfair settlements. And I think that's what, was really disturbing the court. I think the other thing that's really important about this case is, obviously the statutory damages problem, and the fact that the plaintiffs could use, that threat as an easy way to get settlements that add up very quickly. So in my mind, as harsh, quote unquote, as this order was, I think, it's kind of surprising when you think about it's $80,000. I mean, I don't know how much money these people were able to shake down alleged, infringers for. But when you have defendants who are facing $150,000 in statutory damages per work infringed, $80,000 seems like pennies to me compared to
I mean, that's an important point, which is I think that Judge Wright is exactly correct in saying that our copyright laws are not very well suited to these types of situations, which they are copyright infringement. If you're downloading somebody's copyrighted material via a BitTorrent client, that's copyright infringement. There's not a lot of question about that. Now, there's a lot of questions about identity and who people are in this context. But more importantly, the damages is really unclear. I mean, how much are you really depriving a copyright owner of if you download their movie instead of purchasing it on iTunes or whatever? And with the copyright law and the statutory damages regime, means that if you download 3 or 4 feature films, you're going to add up to enormous potential liability, which then gives people who abuse the system the leverage to ask for money that's just below a reasonable defense.
Yeah, that bears emphasizing too. And I don't know that people, lay people really realize that under the statutory damages regime that is in place in the United States, willful infringement, $150,000 potentially per infringement. So that's per downloaded movie, as you were saying, Polk.
Sure.
Evan,
if you start adding that up, that's becomes the GDP of a small country pretty quickly.
Right.
And the other point is that range of statutory damages, which ranges, is $30,000 up to $150,000 per work infringed, that range is a black box. We don't have there are no markers that tell us where in that range you should fall if you're found guilty for copyright infringement. And so that's the other huge, that's why the $150,000 per work may sound far-fetched, but it is possible, and it's something that you can't counsel clients on, you can't predict where you're going to be. So it creates this enormous leverage. And so $3,000, $5,000 you got to scrape together to make these jerks go away, you're going to do it. And it's, applause is, in order for those people who actually stand up to them and, and try to put a stop to this shakedown.
So, Julie, Prenda is not the only copyright troll in the news this week. Someone else we've discussed a lot on the show, very notorious for similar kinds of activities, is Right Haven. They got slapped around this week a bit too, didn't they?
Yeah, they did. And, another deserving of a smackdown, Right Haven. So that was on appeal. Right Haven lost its appeal in the Ninth Circuit in 2 cases that were joined together there, the Hind case and another one, a defendant who his name escapes me. But the point is that the Ninth Circuit affirmed the District Court of Nevada's dismissal of the case for lack of standing. And so Right Haven was found not to own the copyrights that were allegedly transferred to Right Haven, which allowed them to sue people for using their newspaper articles and blogs or excerpts or whatever, that there was no rights transferred, and so they didn't actually have standing to sue. So it affirmed the dismissal of those cases, which the underlying rule that they're saying that this transfer agreement of copyright rights didn't hold up really undermines any case that they had, that any of them that might be ongoing.
There's a similar transfer issue in the Prenda cases, isn't there?
Right. Yeah. I think in the Prenda case, that was the transfer issue or whatever, was like it was where the court was talking about forgery, if I'm not mistaken, that they
Hmm.
had forged this transfer of copyrights and so that they don't actually even own it. So it's, even worse, obviously, in the Prenda case, as far as attorneys and their behavior before a court. But for the Right Haven case, they were trying to create this agreement between the people who owned the Stevens Media, who owns the newspaper articles, and Right Haven, which gave Right Haven pretty much the bare right to sue for copyright infringement, but no other rights. And that, that's not a valid transfer of copyright rights in order to give someone standing to sue on your behalf. So it was an important decision to shut down that kind of operation and to try to, Right Haven was created solely to sue or threaten to sue. Well, they actually did file lawsuits against anyone who was quoting or linking back to any of the Stevens Media newspaper articles. So, putting an end to another, simply a troll in the sense of it exists only to sue people and extract settlements.
Right.
So to play
Okay.
the devil's
Go ahead.
advocate a little bit here, I think that I'm confused about why we think this is sort of the end of either Right Haven or copyright trolling. I mean, it's obvious that what happened here is that they didn't transfer the copyrights correctly. They either didn't know how to do it, or whoever they were getting the copyrights from was unwilling to give up the full rights, which is what you need to sue under copyright infringement. And so there's no particular reason they couldn't go and perfect that transfer, get the agreement proper, and then either refile suits or file suits against others and continue this type of activity. I can understand why a copyright owner might be somewhat reluctant to give up the copyright. On the other hand, the Right Havens of the world could take the copyright and license back a license to the original owner, which wouldn't then prevent that owner from doing things with the copyrighted content. So I'm not as sort of optimistic as a lot of the commentators online are that this has sort of ended this sort of practice. I mean, I think one of the things we're seeing in the patent context is that it takes a while to figure these models out, but it does seem like at least some entities are figuring out how to make it work profitably to engage in what's described as trolling. Although I think it's a little different in the copyright context, but it's not so clear to me that it's not going to continue.
Well, that's what I was going to ask, Polk, is what do you think happens next once we get past the fact that the judge was talking about people being red shirts and red herrings and everything else? What happens now, aside from them paying the fine?
Well, so you mean for Prenda, is that certainly going to pay a fine? And then with the Right Haven, the question is whether or not there are other entities out there that are going to be interested in engaging in this sort of activity. And I think that, the issue that we have to think about in terms of the policies that we have is that we have, a copyright law, which is unclear in many respects, especially with respect to things like fair use and the scope of infringement. It has this statutory damages provision, which is almost certainly well outside the range of what would be reasonable in the context of online copyright infringement. And because of that, there's a very large avenue here or opportunity here for sort of what might be described as strategic or opportunistic litigation. And I think that's something that we're going to have to get a handle on in the long run. This is something that in the patent context is being addressed, although I think not particularly successfully, but it is, we see this in other areas of law though as well, right? This is similar to somebody, slipping and falling in front of your office building, and you settle with that person as opposed to litigating, because litigating costs a lot of money, takes a lot of time, and you might ultimately lose and have to pay enormous amounts of money. And so there's a lot of strategic litigation out there that occurs whenever there's high levels of uncertainty, the potential for really large amount of damages, and it's an area that's problematic across the law. And I think copyright is no stranger to that, and we're just now seeing it. So I would expect, I'd be surprised if we didn't see more of these pop up, and using some of the lessons that presumably these entities have learned from the Prenda and Right Haven experiences.
All right. Well, Evan, do you have any final thoughts on this?
Well, just to kind of tack on to what Polk said, I think he's onto something there, that there's really no reason to think that copyright trolling is dead. It really presents us with the question of whether or not folks like Prenda and Right Haven and any other plaintiffs who go about seeking extraordinary statutory damages, I would actually put big companies like Microsoft and Apple, anybody who's a member of the BSA, in the same camp, where they go and make kind of extortionate threats against people, demanding damages that are many, many orders of magnitude more than what the actual damages would be. I think that presents us with the question of whether or not that truly is abuse of the system, or whether the system is so inherently flawed that that's got to be one of the first priorities of copyright reform, fixing this really cockamamie situation where a plaintiff can be entitled to at least allege statutory damages that are just thousands and thousands of times greater than any calculable actual damages could be in all this. That's what I would tack on to what Polk is saying there.
Okay, and I think I'll make your phrase called out of the sanctions order in Prenda, moral turpitude, Evan, our first MCLE passphrase for this episode of This Week in Law. If you are a lawyer or another professional who might be able to have continuing legal education credit from listening to our show, which is chock full of great educational insights from folks like law professors at UPenn Law, then head on over to the Twit Wiki. There are details, as far as we can pull together for you to help you get MCLE in your state. So, and if you have any other questions, you can always email us to I'm Denise at twit.tv if you want to clarify anything on that front. But we drop these passphrases into the show so that if you need to demonstrate that you actually listened and got something out of this, you can do that. So moral turpitude is our first one. And I think I'm going to take a break here and thank our first sponsor for this episode of This Week in Law, because we have a substantive story about virtual private networks and how they're treated by PayPal that I want to get to after we first thank our virtual private network sponsor, which is ProXPN. ProXPN is a virtual private network that allows you to use the internet the way that it should be, anonymously and without oversight. More than ever, your online freedom and privacy are under threat. Governments and ISPs want to control what you can and cannot see while keeping a record of everything that you do. Plus, that free Wi-Fi at the coffee house, hotel, and airport is putting you at risk because your passwords and sensitive data can be intercepted more easily than you might think. So I want to just let you know, in case, it's possible that people who listen to this show don't listen to the rest of the Twit network, aren't that familiar with all of the shows and what we're about here at Twit. So I want to emphasize for you, in case you're not already aware of this, that we really eat our own dog food with the sponsors on the network here. They're very carefully vetted. They're people that we, the hosts, have tried out and worked with. This particular VPN, ProXPN, has been thoroughly evaluated by our internet security expert, Steve Gibson. And if you want further information on that, please go check out Security Now, episode 400. And he'll walk you through all the details as to how ProXPN works and why it's safe. One of the things that I want to emphasize for you about ProXPN and using a virtual private network to protect your online activity is not so that you can necessarily cloak your clandestine torrenting of porn or anything else, but the fact that these 6-strike programs from ISPs are going into place, they are operating now, and false positives are certainly possible. And we're not really getting good explanations about how and whether there are safeguards in place for that. So if that is a concern to you, ProXPN might be a really good thing to check out. And it's great just from a security standpoint as well. It's a global VPN that works with almost any internet connection. It creates a secure encrypted tunnel through which all of your online data passes back and forth. Any online application can work with ProXPN, including your web browser, email, file sharing, instant messaging programs. ProXPN keeps everything you do online hidden from prying eyes, disguising your physical location and giving you unfettered access to any website or online service, no matter where you live or travel to. It's complete with online privacy through a 512-bit encryption tunnel. It works via OpenVPN or PPTP. You choose which one you want. Protect yourself against your ISP's 6-strike rule and potential false positives that might get you into a legal situation that you don't want to be in. Bypass internet filtering and blocked websites. Bypass geographical restrictions for internet content and online video with worldwide servers in the United States, UK, Asia, and more. ProXPN software from Windows and Mac offers advanced controls, allowing you to select the programs and ports you want to anonymously route through ProXPN servers. It also works with your iOS or Android device, allowing you to use your data plan or public or corporate Wi-Fi with complete and total privacy on the go. There's no app required. World-class customer support is included. And as I mentioned, Steve Gibson has thoroughly kicked the tires on this thing and given it his thumbs up, which is quite a good thing to have. Go to proxpn.com/twit for more information and to sign up. ProXPN premium accounts are normally $9.95 a month or $74.95 for the year, but we've got a special offer. If you use the code TWIL, you'll get 20% off for the lifetime of your account. That's less than $5 a month on the yearly plan. If you're not satisfied, you can cancel within 7 days for a full refund. So go to proxpn.com/twit and sign up with the code TWIL, TWIL. Thank you so much, ProXPN, for your support of This Week in Law. Now, as long as we're on the subject of VPNs, this is really kind of more of a business decision than a legal decision, but it's one of those business decisions where, as Professor Lessig famously said in his book years ago, code becomes law. And what's going on here is that PayPal has decided in various instances in the past to not work with sites that it thinks is suspect from a copyright law infringement standpoint. So BitTorrent sites, Usenet providers, some file hosting services. PayPal has just drawn the line and said, we're sorry, you're too risky for us to work with. They don't want to be associated with somebody who may get themselves in hot water for copyright infringement or enabling users copyright infringement. So PayPal just is washing their hands of them and saying, sorry, too dangerous. We don't want to be guilty by association. Well, now they're doing that in certain instances with VPNs as well. And I think that's really fascinating because there's nothing inherently illegal or, worrisome about using a VPN, although I think PayPal may have a different or more biased take on that. What do you think about this, Polk, deciding not to do business with a company because of its potential for getting you in trouble for copyright infringement?
So I think this is obviously, as you suggested, a business decision by PayPal. It's not at all clear that they would face any real risk of liability here. But on the other hand, what PayPal wants to do is play nicely with a lot of the bigger companies in the online content distribution world, and therefore, those companies would certainly not want PayPal to be supporting in any way sites that they view as engaging in or assisting in copyright infringement. I think that this raises an issue that we see all over the area of internet law, which is we have technologies that have a general application, such as VPN technology, which is, you suggested earlier quite correctly, is important in a variety of contexts. If you're trying to connect to your home office when you're traveling, if you're working at the coffee shop for the day, VPNs are, critical for that type of activity, for the security involved. And there's nothing inherent in VPNs that are related to copyright infringement. And so this is a neutral technology that is potentially under attack because in some circumstances it could be used to engage in copyright infringement activities. I think it's, frankly, for the broader context, it's troubling because PayPal is a large player in the online payment processing space. And so that means that effectively what PayPal can do is pick and choose what types of services are going to be available to end users, which I think is, we should all be concerned about.
The particular VPN in question here is a German company called GT Guard, and this is reported over at Torrent Freak by Ernesto there. If you are interested in seeing all of the seed stories for our show today, you can go to delicious.com/thisweekinlaw/210. We've got all the links over there for you. Ernesto points out that there was a company called TorGuard, another VPN provider that was banned last year, but then PayPal did a review and decided that was a mistake and eventually restored service. So with GT Guard getting now banned, Ernesto over at Torrent Freak is wondering whether we're seeing a new crackdown on these kinds of privacy services. What do you think, Evan?
Well, I agree with Polk in the abstract that this could be problematic, especially when it's PayPal, a big provider. But then again, PayPal ain't the government. It's a private entity, and it should have the ability to operate under its own prerogative and provide services to whomever it wants to. Again, that's just like what Polk was saying, kind of an abstract proposition. I would take issue with saying that this is a neutral technology that's under attack. I don't think this is an attack on the technology at all. My understanding of this is that GT Guard targeted BitTorrent users, so it's a little bit disingenuous to say that the technology itself is under attack. I think that from what I can tell, PayPal is looking to how the technology is actually being used, and it's really beyond any argument that it's appropriate to regulate certain technologies when it's being used in a certain way, despite its neutrality in the abstract. The question of PayPal and its sensibilities, sure, there's all kinds of examples that are mentioned. And Denise, it wasn't lost on me that you said that this is a seed story, and we're talking about BitTorrent. Very nice. That's a nice touch. There's plenty of references in this, but we've also discussed in the years past on the show, PayPal also cut off funding for an ebook provider that was selling too much erotica. So it's no stranger to being a content police in a certain way. And I like what you're saying also, Denise, about it's kind of an example of code being law. Maybe not in the pure Lessigian sense of code being law, because PayPal is indeed relying on its terms of service. So it's, law is law here, law in as much as it's the enforceability of that user agreement and the exercise of those rights that PayPal has to do it here. But, it's, I guess I would have a hard time getting too upset about this because of the particular circumstances here. If GT Guard really is promoting this to BitTorrent users, then why not let PayPal make its own business decisions? Why should we feel that we have some expectation that it's going to provide easy means for someone to to so readily infringe copyright? If they're so intent on infringing copyright, there's plenty of other ways to do it. Use Bitcoin, for crying out loud. Why do you have to worry about PayPal?
Right. So it sounds like, Evan, you're saying this is a marketing thing more than the way the technology functions. If you're going to build something that can be used in a way to protect nefarious or illegal online activity, and then specifically target people who are likely to be engaged in that, then that's the problem that PayPal has.
I mean, it's certainly not a perfect analogy, but we can draw certain points of comparison to what was in the Supreme Court's mind when it, put the smackdown on Grokster. If you're going to market it with this object, then, you ought to be ready and willing to pay the legal consequences for that.
Yeah.
Right. Go ahead, Julie.
Yeah, it just brought to my mind another area of law where in the copyright law that is gray and leads to problems, and that is obviously the secondary liability. And if what eBay is doing is playing nice with content owners, or maybe pressure or whatever, these kind of private agreements seem to be doing the kind of stuff that people didn't want. The reason people were, didn't want SOPA and PIPA last year, and going after, the money source or whatever of the funding for, so-called nefarious activity with these tools. And so I think, they're trying to achieve through private agreements or, business decisions what users were not in favor of legally. And yeah, I think that there's obviously room for private actors to choose how they structure their business or how they do their business. But I think it's something to, watch out for as far as, what is it saying? Is this the best practice of these kinds of companies? If somebody was competing with PayPal and didn't police the, VPNs or these kinds of, providers in the same way, would the content owners, have any beef with them about not behaving this way? It's just interesting to see this problem play out, in this way.
All right. Well, I'd love to get into some fair use talk here. And to do that, we're going to look at some entertainment-related stories. So for folks who remember us talking about the Baltimore Ravens logo and the MPAA asserting fair use in that logo showing up in a documentary film, an NFL documentary film, Julie here was the author of the brief filed on behalf of the MPAA. So Julie is helping them assert their fair use argument in that case. Julie, can you remind us, for people who weren't listening to that show, give us the background of this case?
Sure. Yeah. So the Bouchot versus NFL case is a long saga, maybe 10 years at least, of litigation involving a plaintiff who made a drawing, which was eventually found to be have been infringed by the Baltimore Ravens and the NFL when the Ravens moved to Baltimore, started their franchise in Baltimore, and their original logo was, the bird logo was found to have infringed a drawing that Bouchot made that somehow made its way and found its way into the corporate headquarters and, either purposefully or not influenced the actual drawing that was used as the logo. So the logo that the Baltimore Ravens used from 1996 through 1998 was found to infringe Bouchot's drawing. So what happened was, although a jury found copyright infringement, the jury trial on damages found that there were zero damages, monetary damages, because none of the value that the NFL or the Ravens had derived from the logo was attributable to Bouchot's drawing. And so they got no money out of it, but he has continued to sue them for injunctions trying to stop the use of this logo as it appears. So what happened after they were found guilty of infringement, the Ravens and the NFL changed the logo. So the new logo going 1999 forward, doesn't infringe, has nothing to do with it. So all of these uses involve use of historical footage where the logo appears. So the current case, Frank Bouchot is suing because the NFL has footage of its players playing during the seasons between 1996 and 1998. Some of them are highlight films where they're showing the top 10 draft picks, for example. And one of those being a player from the Ravens. They, show them in their draft year, and that happens to be one of the years where the uniform included this infringing logo. And he's trying to get an injunction to stop that use of his logo. The other uses at issue in this case involve uses around the stadium where there are pictures or paraphernalia from those inaugural seasons that show the history of the Ravens team, and he's saying where those pictures include any fleeting inclusion of this original logo, it's an infringement, and they should be enjoined from doing that. So at the district court, the NFL and the Baltimore Ravens won. The district court said that these uses were a fair use, and now on appeal before the Fourth Circuit, Bouchot is arguing for reversal. This will be the fifth time the Fourth Circuit has addressed issues in this case, so it's going on for a long time. So that's background of the case, the brief that we filed was on behalf of the International Documentary Association, Film Independent, and the Motion Picture Association. So those were the amicus parties that signed on. And I think, the obvious important things for fair use law here are the use of copyrighted material in a historical nonfiction setting to accurately portray history. That's what's at issue here. Bouchat wants to, stop anyone's ability from using footage and, other paraphernalia that may show this logo. But the fact is, that's what that team looked like. That's the actual history. And so it's an important issue as far as for documentary films are concerned, MPAA members who make nonfiction films to, not let copyright, control the use to accurately portray what has actually happened in the world, or or to accurately portray history. And so he's seeking this kind of power to whitewash history, which has its effects on this case in particular, but obviously the potential downsides in the future for other uses, similar uses, are at risk, which is why we felt it was important to submit a brief on behalf of the Ravens and the NFL in support of their position.
Yes, the documentary film project at Stanford has been around for several years now. Is it 5 or 6 years?
Yeah, we since 2006. So 7 years now. And the documentary film program, we represent filmmakers and advise them about using copyrighted material without a license in their films. So that's on the production side, advisory, trying to help them be able to rely on the fair use rights that they have, to advise them about when things are or aren't compliant with best practices in the industry and what is or isn't likely to be a fair use. And so that's the advisory side. And so obviously it's in our clients' interests to fight for these, precedential rulings that affect their ability to rely on fair use in making their creations.
Were you surprised when the MPA decided to become a signatory to this, or do their interests line up nicely with this?
Well, their interests do line up nicely on this. Obviously, these. I think what's important about getting these multiple parties together on one brief was just to point out how kind of out of line with the way that a large consortium of people think about fair use, how out of line Bouchat's position is, and so it was surprising. There's the idea of our position or the way we see copyright law, or the balance between, people being able to use copyrighted material to create new works, being often different than what you would expect from large content owners, particularly major motion picture companies. But it really wasn't that difficult. We did it, we wrote the brief, and they were interested. The MPA, this case in 2010, we had also filed an amicus brief in support of an en banc hearing, rehearing, which was eventually denied. But we filed an amicus brief, and the MPAA filed one too. So we were both on the same side there before in 2010, just not on the same brief. And so, so I guess it wasn't a total surprise, but it was nice that, we were all able to agree on the same language and the same pitch as far as what the story is that we were telling.
So this is pending in the Fourth Circuit. When is oral argument scheduled? Do you know?
Oral argument is not scheduled yet. The plaintiff's reply brief, I believe, I think it was just filed. So so we're waiting. We'll wait for an oral argument date, and then it'll be several months before a decision is issued.
All right. Well, we will hang in there and wait and see how the fair use argument flies there. Evan, we talked about this quite a bit a few weeks ago. Do you have any further thoughts?
Just to say again, this is, an area where I see copyright is of extreme importance, perhaps the most important way in which copyright affects us, because this has to do with our cultural heritage and posterity and how history will view us decades, generations down the way. And, the impact of copyright in both, pure copyright and also, the anti-circumvention provisions and the DMCA, those things impact so closely our cultural heritage and how much of it's going to be available for expression, use and expression, and to be kept around. So this is just great work that Julie's doing, very important, and I'm all for it.
Thanks.
To me, this is a great case, in part because it shows that everybody, the MPAA, documentary filmmakers, everybody wants fair use to be clearer and better able to actually accomplish what we think it should be accomplishing. And the idea of fair use is really, this is what documentary filmmakers are doing, is precisely, at least the way I think about fair use, what fair use is supposed to allow. And yet you still have to litigate it. It's so confusing. The factors are so unclear. Different cases come out different ways. Different circuits have their own spin on it, that you have to litigate all these cases, which, leads to higher and higher costs, and means that effectively fair use becomes a smaller and smaller component of what our copyright law is about. And as Evan said, that has real implications for what people can and can't do with materials online.
Yeah. Can I just respond to that quickly? I think, what's really particularly interesting about this case is exactly that point, which is in the nonfiction biographical kind of context, these kinds of uses have become pretty established. And, we see it with our work with documentary filmmakers, where we can advise them on how to use clips and feel really, that they're, fair use is never a slam dunk. And of course, you can always be sued for something or other. But these kinds of uses have been really, well established and pretty strong, and to the effect that people rely on them, and they don't get sued, and they can get insurance coverage for their films that covers the uses that aren't licensed and that kinds of stuff. We saw recently a Ninth Circuit decision where not only was the fair use summary judgment order affirmed, there was also an affirmance of a attorney's fee award in favor of the defendant against the plaintiff who sued for using, a clip in the Jersey Boys musical. And so, the courts are like, no, this is clearly a fair use. You're using a clip to tell history, or, as a part of a biography. And so, what I thought was really important, and I think the fact that all of these parties came together on this brief, is that this is well established, that this shouldn't be a hard question for the Fourth Circuit to get right. I mean, it's obviously important. And so I am really hopeful that my kind of optimism about, the clarity that has been brought to this area can be, upheld by the Fourth Circuit if they, take a real thinking approach to this case. Obviously, every case has its different facts that create different wrinkles. And I think obviously what's happening here with the Fourth Circuit case is, that maybe there's some sympathy for this plaintiff who was never compensated for his use and whatever, but that shouldn't, create this really detrimental rule, which goes against what all the other circuits have held, which is, this kind of historical artifact and use of, copyrighted material in this way is a fair use. And you're right, it's really important to get that consistency, because otherwise people don't feel strong enough to be able to rely on it.
Well, somebody who either garners sympathy or, I'm sad to say, sort of hatred and disgust in the entertainment arena is Dr. Phil. So who knows how that will play out in his lawsuit here against Deadspin, which is a Gawker property, which tends to not generate too much sympathy at all. Dr. Phil is upset that Deadspin posted juicy portions, perhaps the juiciest portions, of his interview with, oh gosh, how do you pronounce this? Ronaya Tuiasosopo, who is the person behind the Manti Te'o girlfriend hoax. And so we've got another fair use issue coming into play here, depending on how exactly this was used by Deadspin. You know, I'm not sure. I haven't gone and looked at how it was used, whether there was a lot of commentary or if this was just sort of, we've got the scoop, here you go. Julie, can you fill us in?
Sure. Yeah, it looks like, yeah. So what I could tell from the posts that are still live on the Deadspin site, it looks like they were obviously Deadspin was the one who broke this story. So it's really a huge story on their website for weeks. And so when this guy went on Dr. Phil, they were talking about his appearance and what he had to say. And then, augmenting that and demonstrating what they were talking about by showing clips from the show. And so Dr. Phil or his company or whoever are suing Gawker because Deadspin used clips of the show without permission. And so this case will raise, as far as how much of the video were they using, and was it a fair use or not to, show the clips to supplement the article that they were writing about the show. This is an area where I think, the issue that they're complaining about, or what's really setting them off, is this idea that Deadspin showed clips of the show that, kind of ruined this cliffhanger effect they had, because Dr. Phil had 2 episodes, one showing one day and one showing the next. And it was the second episode where you were going to get to hear this guy talk in his fake female voice or whatever. And so, the part of the complaint is that Deadspin scooped the Dr. Phil show by showing those clips before the Dr. Phil episode aired in a lot of the markets where Dr. Phil exists. So it's an interesting issue in fair use, as far as I guess you could call that unpublished, or more in line in the whether the original work had been published yet or not, or whether you're just scooping them for an advantage to get those viewers. My question is, how many people do they think really overlap between reading, Deadspin, as opposed to, the people at home watching, Dr. Phil? That'd be kind of interesting to think about. I don't know if legally it plays into it, but I kind of doubt.
Well, it does, really, right? In the fair use
might,
analysis.
Yeah, it would. But and especially in the idea that they're being, that there's some kind of scoop here or not, that could be downplayed. But, it'll be interesting to see.
One of the interesting things about this case for me is that it raises an area of the copyright law where we think, from court cases where copyright law is, in a sense, at its strongest, which is unpublished material that has not yet been published or offered to the public. The Supreme Court has, made it clear that is, the right to choose when you first publish is among the most important rights you have as a copyright owner. And what the Dr. Phil lawsuit claims is that Deadspin essentially took their right to do that. There's some interesting factual issues just from reading the news accounts as to whether that's the case or not, because it appears that what Deadspin did was took some of the clips from a show that had already aired, but they posted it just before most of the possible viewers of the Dr. Phil show were able to see it. So they were sort of very quick about posting it, which is why Dr. Phil claims it's a scoop. But it does raise this issue, which we don't see very often in the online context, which is unpublished material or potentially unpublished material, and what is the scope of fair use for that. And I think it's a pretty narrow scope for fair use.
Yeah. I think that's right. We also point out that, Congress has specifically said that the fact that a work is unpublished is not, is not an automatic, killer of any fair use defense, in response to the Supreme Court's, and follow on cases to the Supreme Court's rulings about unpublished works. But for me, what's interesting is that when I talk to people who need to rely on fair use, let's say for scholarship, but they are using unpublished works, you get these kind of cases where the courts are sympathetic to somebody, a plaintiff who's allegedly been scooped or something. It sets up some bad precedent for people who want to rely on materials, let's say letters or something from an estate to write a biography or write a scholarly piece about someone, and they need to rely on these unpublished materials. And so, where the law comes down on that is really important for a lot of those users as well. And so, hopefully, if there's any kind of ruling or any kind of order that comes out of this, and it has to do with whether it's unpublished or not, we get some nuanced understanding of, fair use might not be okay if what you are doing is really scooping and usurping the market for the original, but it's not simply because it's quote unquote unpublished or not.
When I first heard about this case, I thought of the Harper and Row case, the Gerald Ford quotes case, and actually in IRC, for those of you in IRC, Franklin Graves is kind of dropping some knowledge about that case as well. And it sounds a little bit like that, because what Gawker sounds like it was doing here was going to the heart of the matter. These little clips, and that. The Dr. Phil show seems particularly susceptible to that, because so much of Dr. Phil's style is putting stuff in concentrated little quips or whatever. You're an idiot and your mother-in-law is too. If you just take that and have that as a quip, that's very attention getting, and if there's something like that that's going to be scooped, that would go to the heart of it, just like the Supreme Court held in that Harper and Row case. It can be just a tiny little portion of the overall work, but if it really is a spoiler like that goes, and I think that analysis mostly falls under the market effect, right? Where if it's just if it goes to the heart of the work, somebody may actually not, in this case, watch the show because they could already had the effect spoiled by whatever this guest did on that.
Right. I mean, part of this that's interesting, too, is because you have, in a sense, two different types of media here, right? Where Deadspin, what they want people to come and look at a quick video, spend a couple minutes on the site. That's what they need. They need the page views. They need the clicks and so forth. What Dr. Phil needs is something very different. They need people to sit there for half an hour or an hour so that they can show you advertisements over and over again. So it's a very different sort of need, and I think that's where a lot of this dispute comes out, which is Deadspin's perfectly happy to show simply the juiciest parts, which might have been the only interesting parts of the video, I don't know, or the interview I didn't watch, but Dr. Phil needs people, as a matter of the economics of it, to come and watch the full 2 hours each or whatever it is, in order to make the economics work.
Paul, let's take the unpublished nature of the clip out of the equation for a second. Let's say that it had run and that Dr. Phil had been able to pick that time of publication that the Supreme Court has said is so important. But then Gawker Media and Deadspin took the juiciest parts and put it on their website. Do you think they'd have a better fair use case there if all they had done was use the clip?
Well, I think they probably have, at least if they can take off the table this scoop issue. I think they not necessarily have a better fair use case, but they certainly have a much better case in front of a judge, because I think, as Julie said, and I agree with, a lot of judges tend to be sympathetic to plaintiffs who claim that this scoop is somehow undermining the economics of their entire work. I think that anyone who thinks they know how a fair use case is going to turn out is, joking. There is no way under current law to really know what fair use is. I think that's a major flaw with our copyright law. I think almost everybody who deals in the area would agree that you really don't know. I think you're right that if indeed there's no scoop involved here, then Deadspin's claim is stronger, but it is still not clear whether this is really fair use or not, because they did use the actual video of the Dr. Phil interview.
Yeah, I think what actually will be a determining factor is what was written in the story and how was the video used. And so I think, let's say that the story or whatever Deadspin was writing about it was look at how Dr. Phil treats this subject, or critical analysis of that, of his interview or something. Using the video to support that kind of critique, I think, is very squarely in fair use, and would be one that would be, obvious, on one end of the spectrum, a really strong fair use defense. You might get a judge who's going to get it wrong, but you'd have a really strong claim there. And so, like any fair use case, it's very fact dependent, and so it will depend. So yeah, I think if you take out the scoop issue, Gawker is, might have a very strong defense here, because using the video to support what they're saying when they're talking about what happened on the show, depending on how much of the show they used and, what clips they used and what the text of their article was, I think, it can be a very strong case.
Yeah, well, it's near and dear to our hearts here at the Twit Network, of course, because we do commentary shows where we will incorporate clips from other things. And we're a different business model. We're not trying to highlight those clips as small things on a website to get hits and feed advertisers, but they do become integral parts of our shows when we want to show off, here's what somebody's had to say on this topic that we're otherwise discussing, or here's how someone else treated it. And I'm wondering, too, if Gawker, as you said, Julie, had been following the issue so closely and broke it, whether they might have a decent argument just by being able to say, hey, we're a news source on this topic. We're arguably the news source on this topic, and we're just keeping our viewers informed.
Definitely. Yeah. They are the leaders of this discussion, and so they are very much a news source on this, and they were the ones who broke the story, and they are following it very closely. Their readers care about it, and the different twists and turns are, how did this interview go, and what does this guy sound like, and let's talk about that. And so yeah, I think it's really important to protect the right to use those clips and that kind of thing to fodder other discussion and to further the thing. And so, like, the idea that by nature of who they are, the Dr. Phil show then controls this monopoly, and it can be the only one who shows this guy on TV, I think that's wrong. And so there is lots of discussion that builds off of that. And so using clips in the right context and in the right, with the right amount and substance, they're very much within their fair use rights to do that.
All right. Well, as we've been talking on this show all around, there are some things that are not quite wonderful about the way that copyright law exists and functions and maybe is variously interpreted in the United States. And Congress is actually starting to pay attention to those issues. We're not sure if that's a good or a bad thing. We'll explore that more in a moment here after the break. We're here with Polk Wagner from the University of Pennsylvania Law School and Julie Ahrens from the Center for Internet and Society at Stanford, and Evan Brown from the Info Law Group, and me. And we wouldn't be here without the sponsors for the show. Our second sponsor, much like our first, is all about conducting your business online with safety, security, and confidentiality. And that sponsor is ShareFile. It's not only what we do at work, but how we do it that makes the difference. Our flow of information needs to be ongoing, collaborative, and time efficient, whether we're working at the office or on the go. Well, ShareFile helps you do all of that securely and easily. It seamlessly integrates into your daily routine, no matter where you are and from any mobile device. With ShareFile, files of almost any size are sent as secure links. Notifications are sent to you when they're opened to track their progress. Files can be password protected for ultimate control. And by sending them as links, done are the days when you're wondering, gee, did that email attachment get through or not? You don't have to worry about it, and you don't have to worry about the security of the links. With ShareFile, that is a wonderfully secure and confidential way to make sure that clients, if you're a lawyer, opposing counsel, if you're a lawyer, just business contacts in general, are able to communicate with you, collaborate with you on documents, view things that you need them to see in a safe, secure, and confidential way. You can set up folders that make that collaboration even easier, where everyone can add to the same location on ShareFile. It will change the way you work. To help you get started, I have a special 30-day free trial offer with no obligation, and you'll see the difference right away. So to get on that offer, head on over to sharefile.com today. Click on the microphone at the top of the homepage and enter TWIL, T-W-I-L. That's sharefile.com and type in TWIL. Thank you so much, ShareFile, for your support of This Week in Law. So let's head on over to Washington and see what those lawmakers have been up to. Lots and lots of stuff going on related to the internet, various bills being proposed. One that actually passed is the Marketplace Fairness Act. We've been watching that for the last few weeks. It finally did pass. This is the act that's going to require states to begin collecting sales tax or fix their existing taxation laws so that that can happen on internet sold goods. Depending on where you are on the political spectrum, this is either the end of the internet or the way things always should have been. What do you think, Evan?
Somewhere in between, probably. If this were a new tax, I would certainly be very much against it. But it's not a new tax. And I think most people understand that, but there's a tendency to misunderstand that perhaps. I mean, what this is calling for taxes that need to be paid and are required to be paid by the consumer now. You're supposed to report these types of sales tax on your state income tax return when you file in each April. It's going to switch the obligation from the consumer to the online retailers to collect the tax and then put it into this system that's yet to be fully developed, but in no event will be anything other than Byzantine, to make sure that the states get the sales tax on the purchase of these goods that they're already lawfully entitled to get. So it's pretty easy to take a position on this and to back it up with some good policy. I think advocates on either side could make very sound and very valid arguments. A couple of things, I think, for me, shift the balance into saying that this is okay and this is probably the way it should be. One of them is the reason I've already said it's not a new tax. It's just seeing that the taxes that are already obligated to be paid are paid. And the second is, I'm kind of loath to say leveling the playing field because I don't think that's what the role of government always is to do, to level the playing field. There's always a need for competition so that well, I don't know. I don't want to go down that rabbit hole, actually. But what I think that it's important to see that the interests of the brick and mortar retailers are being met here, and their interests are served in that way because the way that there's been so much internet sales tax avoidance over the years has been to the detriment of the local brick and mortar retailer. And if we're truly about business and competition and all that, good, wholesome things like local businesses thriving, then we should be for this that doesn't unfairly tilt the scales too much. I'm trying to avoid my own metaphor that I showed disdain for by not saying level playing field. Maybe I should just go ahead and say it. Can you see this?
Just level that playing field.
Go ahead. Getting way too caught up in semantics here. So you can see, it's easy to take a position either way because the other side equally can just say, I don't want more, more government, more money. It's going to be bad for internet business. You can just as easily make sound arguments on that side. So, but I think for me that the scale tips into supporting local business who've had to suffer because of this disparity over for however long modern e-commerce has been around.
Right, and the disparity is that individual consumers making online purchases have been under the onus, under the law, of being responsible for reporting and paying the tax on their purchases on their own individual tax returns. And, I'd love to see statistics on how many people actually do that in the nation. I've never had, but I'm sure it's a minuscule amount. So this is going to put it on states to ensure that those taxes are collected from businesses as opposed to the consumers. Polk, is this a better solution?
So I think that the way that I think about this is that for many years we've had essentially, effectively a tax subsidy for online businesses. We've, as a matter of policy, determined back in the Clinton administration that we weren't going to apply taxes to the internet in the same way that we would apply those same taxes, sales taxes, to real world sellers. And I think that had a lot of good effects. I think you've seen a real explosion in terms of these online distributors, Amazon, chief among them, but many others as well. But I think you can certainly make a pretty strong argument at this point that, the subsidy has fulfilled its mission. These companies are certainly able to stand on their own without additional help, and it's time to make it have them fall into line to where everybody else who sells goods does, which is collecting tax and sending it to the appropriate taxing authority. So my view is very similar, I think, to Evan's, which is this is putting things into a place where it seems like they, arguably should have been for a while. Although I think 5 years ago, 10 years ago, you could have made a much stronger argument about making the internet tax-free. But I think that time has passed, and the online distribution has proven itself to be a viable business model, and there's no reason to expect that they won't continue to be just as viable with sales taxes.
Julie, anything on this?
Yeah, I agree with both Polk and Evan, and I would also add that I think, as was written about on the Slate piece about this, that the other good thing that comes out of this Fairness Act is that the legislation requires that states simplify their tax policies in order to begin requiring internet companies to collect the tax. And so I think that, that's another benefit that we get out of it, because, for people pushing back on why they shouldn't have to collect the tax, it's because it's too cumbersome or something. You get, a simpler policy in order to let states have, get this power to force them to collect the tax. I just wanted to ask one question, Polk, about the idea that it's a subsidy for the internet businesses. I agree, but I do think it's kind of funny to call it a subsidy when the tax is supposed to be paid anyway by the consumers on their tax returns. So it's almost like a subsidy by virtue of tax evasion or something. Like we all know, we all know nobody's going to actually be honest and report how much money they spent on internet goods and pay taxes accordingly, and so we'll consider that a windfall for the internet companies. Although you could also, I guess, think it's a subsidy to the internet companies just because, or online retailers, just because they don't have to deal with the collection and the costs and those kinds of things that are associated with collecting and paying out the taxes on behalf of their customers. So.
Right. I think it's more on the latter, right? Which is what we've done up to now is essentially allow online businesses, internet businesses, to avoid having to build in that infrastructure to determine where people live and where the appropriate taxing authority is, what the right rate is. I mean, that's not trivial, although one expects it won't be, it's not going to put anybody out of business, I wouldn't think, but it's going to require some efforts. And so that was sort of the subsidy I was thinking. But yeah, it is sort of a funny subsidy because it's it is one that seems to rest largely upon the idea that people aren't going to pay the full amount of this tax anyway.
Right. And we should point out, too, that there is a small business exception from the Marketplace Fairness Act. If you're making less than $1 million in annual revenue, you don't have to collect and do the extra work. So, all you folks on Etsy, you're safe unless you're doing really, really well. Evan, anything final on this?
No, I think I was just going to poke fun at Polk and Julie for being academics and having such a semantic argument about the subsidy. I was getting a kick out of it.
Yeah, no, but I had the same thought too. It is funny to call it a subsidy when it's just sort of a wink, wink, nod, nod. Nobody's going to pay that tax kind of subsidy. Let's make level playing field our second MCLE passphrase for the show and talk about something that has just been introduced, H.R. 1892, the Unlocking Technology Act of 2013 from Representative Lofgren, who I think is also responsible for Aaron's Law. Isn't she, Julie?
Yes. Mm-hmm.
Yes. So tell us about the Unlocking Technology Act.
Okay, so that's a new bill that Congress introduced that, would aimed at this whole cell phone unlocking, controversy that we've had, and I know you guys have covered on this show about, whether we need, the DMCA exemption in order to have cell phone unlocking, or whether, we can actually pass legislation that deals with this in a broad way. And so the feedback that I've read about it is that this is a positive bill that, would, instead of having these kind of Band-Aid fixes, it actually is a permanent fix that would help, that would make clear that unlocking your cell phone is not an unlawful circumvention under the DMCA, and that this would also, I think the bill also covers not just the act of unlocking your cell phone isn't a DMCA violation, but also that the tools that you need to do the unlocking are also not unlawful to create those and distribute those tools. So those are really important pieces to making it possible for people to actually unlock their cell phones without worried about copyright infringement, which, when you think about it, it doesn't even make any sense that those two, things go together, that unlocking your cell phone and, that you would somehow be violating copyright law at the same time. So I think, it's an important step in this fight for, the freedom to be able to, use your phone the way you want to.
Right. Picking up on one.
To me,
sorry. Yes. Yeah. Go right ahead.
One thing that Julie didn't really mention is that this actually, so although it specifically notes the cell phone unlocking, I think the really, really blockbuster piece of this proposal is that it would change the definition of circumvention in the anti-circumvention provisions. So the DMCA has provisions in it that prohibit the circumvention of technology that's intended to prevent copyright infringement. But how it does not, however, seem to require that the circumvention be occurring for the purposes of any actual copyright infringement. What that means as a practical matter is that you can't typically use fair use as your defense for circumvention, right? So you can't say, well, I had to circumvent because I was trying to engage in my legitimate fair use of a work, because that doesn't seem to apply under Section 1201. This bill would change that definition to make clear that the underlying purpose of your circumvention would have to be infringement in order to be actionable under 1201. That's a really important change, and one that's going to go way beyond anything to do with cell phone unlocking, but is going to offer a whole lot more protection to people who want to break technological protection mechanisms in order to create or to do fair use things with them.
Yeah. That's a great point, and I'm glad that you added that. I think, whether it's a change or a clarification, whatever, I think people have been arguing that in these cases with the under 1201. But just to give a clear example for people so that they understand what we're talking about, one of the exemptions, an important exemption that has been given and has been advocated for is, for example, breaking the encryption codes or whatever the mechanisms on DVDs that documentary filmmakers, for example, need to break in order to make fair use of clips that they're going to use. So otherwise, their use would not be a copyright infringement, but they need this special exemption so that they know that they're not in violation of the DMCA when they take the DVD and remove the encryption in order to get the clips that they need to make a fair use. And so Polk is right that this bill would make the law perfectly clear that doing those kinds of things in furtherance of activity that's not an infringement in the first place, it cannot be a violation of this section of the DMCA.
Do you think it would really help anything at the end of the day? I mean, because, yeah, the law may change what it says, but it doesn't really get to the problem of the fact, and I think we were talking about it earlier on this call, or, it's something we all have probably talked about 500 times at least, is that, to litigate the question of fair use is, well, you've got to litigate the question. It doesn't.
Well, I
doesn't
think
spell
it
out.
changes.
I think it does too, because I work with filmmakers, for example, who feel very secure and can get an insurance policy and can make their film and make uses that are perfectly very soundly fair use. Yeah, they might be sued, but you might be sued for anything. But if you don't, you add this other layer that, well, actually, in order to get that clip, which I feel very, on very strong ground that I can use, in order to get that, I face this potential liability for violating the DMCA anti-circumvention provisions. Then that adds just a whole nother layer of risk without, specific exemption, which the documentary filmmakers have been able to get, or clarity in the law that because they're not doing it for the purpose of infringing, they cannot then be liable for that violation. And so I do think it is, as a practical matter, very useful.
I think what matters here is that if the language says that in order to be circumventing, you have to be infringing copyright, or your purpose of circumvention has to be infringing copyright, then what that's going to require is essentially the plaintiff, at least the way I read the proposal, the plaintiff to show that your use was not going to be fair. So that changes, in some sense, the balance and the burden in these cases, which I think could have a real impact for people who want to, break encryption in order to make fair use.
I guess so. Obviously, I would need to think that through, because fair use is an affirmative defense, right? So saying that it has to be an infringement would somehow implicitly make it an additional element in the plaintiff's case for circumvention that it's not a fair use.
Well, I think we'd have to see what the courts would do with it, but one could see how the courts would say that what we're going to have to do before we even go down the road of determining whether circumvention has occurred is at first deal with this underlying issue of infringement, and then what the proofs are on that, I don't think we're going to know. But it's quite possible. I could imagine a court saying that the plaintiff is going to have to show that the purpose was unrelated to fair use. I don't know. It might be that they just treat it as normal infringement, where, as you say, it's an affirmative defense that's going to have to be proven by the defendant. But I'm not sure that would necessarily be the case if the circumvention is what you're claiming, right?
Yeah. All I know is that I can't believe that I'm almost to the point of saying that Zoe Lofgren didn't go far enough in her draft legislation. That's put me in a weird position. So.
Well, I think the way to look at this is, if you think about something that someone's like, well, that's not an infringement, but I still have a claim against you. Without this clarification and without this, making it specific that you would also have to show that you are, a copyright infringer in order to go after them. That, to me, that does change the picture. It changes it not just on litigation like defense, but obviously on advising people and the risk that they're taking when they're using copyrighted materials. I think it's really important.
Right. Hallelujah that this is out there, and the site Fix the DMCA is all for it and is suggesting that people take a moment and tweet Representative Lofgren and also Thomas Massey and Jared Polis, the co-authors here. But the devil in these things is often in the details, as you guys have been discussing. And I'm worried about the intent part in subclause. Let's see, what is it? A1C3 or something. The draft of the bill is a little bit convoluted to get to. But the part where it's saying that it's not a violation of the section to make a product or service that is primarily designed or produced for the purpose of facilitating non-infringing uses, and that it's the intent to infringe that becomes determinative here. That's going to be really difficult to play out in litigation, I would think, to show what the intent of the product or service is. Do you agree, Polk?
So as always with those sorts of things, the intent language is going to be difficult and going to require a fair amount of litigation and probably many years before we really know what it means. That said, it tracks reasonably closely, I think, with what the Supreme Court did in Grokster, which is, really put an emphasis on purposes and intent with respect to copyright infringement when considering liability. So I don't think it's particularly unusual, but it is. I think your point is exactly correct. This is a confusing aspect of the bill and one that's probably going to take a lot of years to resolve. That's great for me since I'm in the lawyer manufacturing business. So so I'm happy about that.
Yes.
Congress never fails us on that regard. So.
Julie, how do you think the intent point's going to play out?
Well, I think what's important is when you think about the way that the DMCA and these anti-circumvention provisions have been applied to things that we think are like way too broad or, didn't really involve copyright, protection measures or whatever. I'm not totally down, in the nitty gritty and the details of these things, but obviously the cell phone unlocking as an example, you're not unlocking it in order to infringe copyrights, or like the garage door openers or those kinds of things. And so, I think this language is just, makes it clear that that's what the DMCA is getting at, is protective measures to prevent copyright infringement. And so if you can't show that they were creating these tools or using these tools or doing the actions in order to infringe copyrights, you shouldn't be able to sue them under the Digital Millennium Copyright Act.
And isn't that sort of kind of what the law is already, though? Like under the Chamberlain case, you were talking about garage door openers. Let's go there. Why do we even... I'll stop there.
No, go ahead. Sorry.
Well, no, I mean, that's my question.
Why do we need this change? Because of Chamberlain is what you're saying.
Well, right. I mean, yeah, and that's only one circuit. And I think the Sixth Circuit said something similar in the Lexmark case where, it ain't no DMCA circumvention if there's no copyright to get to. So, that's why this is good that Zoe Lofgren is saying this, but if we really want to solve the problem, don't we want to, really get to this fair use problem that we've been kicking around for years?
Well, I think the problem is that if the statute's clear, you don't even get to court, right? So if the statute was clear in the first place, you wouldn't have to go to court over whether the garage door opener is covered or not, right? So if that's the point, then those are the kinds of things that give us clarity and don't let it just be litigated and see how the courts interpret it. I
hear you, but we all know that plaintiffs make dumb decisions, and the dumb decision in this case would be, in this hypothetical case that we're talking about here, is to think that their work is protected by copyright. So whether or not the instruction we get from an amendment to the Copyright Act or from case law is that if the ultimate question is this work is not protected, if this work is not protected by copyright, then there is no circumvention here, then the propensity to litigate that question, from the part of aggressive plaintiffs is going to be the same whether or not it's in a statute or coming from case law, wouldn't you think? I hear where you come from. I don't even know why we're really disputing this.
Yeah, no.
I mean, all saying the same thing.
Right.
Yep.
No, I agree. I just think that what happens is the chilling effect of the possibility that that somebody could litigate or that somebody could potentially have a claim that really has legs to it. And so for me, the clarity in the actual statute that makes all of those things less possible is something that we want. I mean, is it perfect? No. Is it, going to stop any vexatious plaintiff who might want to sue over whatever? No, but, if Faulkner's estate is suing, over a movie quote of one line from his book, that's because anybody can sue for anything. But that doesn't mean that we shouldn't, create clarity where we can and try to stop these kinds of claims before they get started.
I'm with you.
So back to the intent point for a second. Somebody remind me what the DVD decryption company that was sued into bankruptcy was called. This was a few years ago.
DCSS.
Oh, shoot. I can't remember.
I have like ABC and 123 in my head as part of their name, but am I close?
That one. Yeah, I'm talking about just the algorithm, right? The DCSS.
Right. No, there was an actual.
Software was DECSS, right?
Right. But then there was a company that was selling something, marketing it for backup, that would do the DCSS for you. You could buy their software, and they were sued and they went under. So, this intent point is going to come up for that kind of company again. They're going to be there. And Virgil in IRC is asking, will this apply to backing up DVDs, Blu-rays, and the software made for doing that? And the answer to that is it depends. It depends on how good the company is going to be at showing, hey, this is only intended for backup. And this is back to your fair use point, I suppose, Evan. Not
321 Studios. Is that what you're thinking of?
That was it. Yeah.
Yeah. Spider Bite in IRC. Coming to the aid of our good efforts.
Much appreciated, Spider Bite. So, do you think the son of 321 has a chance under this Polk?
Well, I think they have a better chance than they would have prior. And I mean, of course, we're a long ways from getting anything like this enacted. One thing we know is that a lot of these types of proposals don't go anywhere, and it's pretty tough to get any reasonable reforms to copyright at all. But I certainly think that if this redefinition and some of these changes that have been proposed are in place, then there's certainly more hope for those types of companies than there are currently.
All right. Well, we have one more piece of pending legislation to discuss, and this one's on the patent front. So why don't we just go ahead and play the patent bumper? Kaboom. And by the way, happy birthday, Franklin. We love you. We love our bumpers. Those were made by our intern last summer, Franklin Graves, whose birthday is today, Evan.
That's what I hear. Yeah.
Yay. Very exciting. Happy birthday, Franklin.
Happy birthday, Franklin.
All right. So let's talk about Charles Schumer's bill, Polk. Looks like they want some gatekeeping on patent suits before they can get filed.
Yeah, so this is a really interesting proposal, and one that we don't know a lot about yet, since it appears to be merely something that Senator Schumer has issued a press release on and given a couple of brief interviews about. But he says he's going to propose an addition to the the Patent Act that would allow, in many cases, he specifically notes high tech and finance industry cases, that they would allow defendants to what he describes as run the patents by the patent office prior to litigation beginning. It's not exactly clear what he means by that, whether this is some sort of additional review. Senator Schumer has before proposed certain types of additional review, some of which did make into the 2011 American Invents Act. So it might be something like that. One of the things that struck me is he gave an interview where he suggested that this would not be a big deal in terms of timing, because these reviews would only last 1 month. And so anybody who does anything with patents knows that that's a relatively silly suggestion, because nothing at the patent office lasts 1 month. It lasts a long time. They're very, very heavily backlogged, and the additional overhead that would appear to be required to vet patent cases prior to them going to complaint, I think would be pretty significant. So I'm fairly dubious about whether this is actually going to work, or even indeed what it is, although it's certainly one of the more interesting proposals I've seen in a while.
Okay, Evan, this sounds like a good thing to me. What do you think?
Well, yeah, of course, there is no bill to read, right, Polk? I mean, I think I heard you say that. In any event, I haven't read the bill, whether that's because it hasn't been issued or whatever.
No.
But I guess the way that I would look to critique this is to start with the question, wait, haven't these patents already been run by the patent office once before? And that's called, like, the examination process. Why add this other barrier, and is that going to put too much of a load onto the already greatly overworked and underfunded USPTO? Is that really going to discourage plaintiffs? What's the net effect? So that I have no, solid critique to give to it, but that's kind of the framework that I would use for the analysis if I was wanting to take a critical eye at something like this.
It would be pretty horrific if more bad patents were issued because everyone was deciding whether or not patent lawsuits should be filed. Bad situation.
Right.
Julie?
Yeah, I don't have much to add there.
Okay, let's quickly look at something on the privacy front. So Reddit has a new privacy policy authored by our friend Lauren Gelman. Is this a good thing, Evan? Did they need a new privacy policy?
Well, never read the old one, so who knows? Which would be nothing new when it comes to these things.
Right.
Lauren is our friend, and so everything that she does is written well. She's very smart, and I've looked at this, and some of the critiques is that it didn't perfectly execute what it set out to do, which Lauren actually in participating in a subreddit that was discussing this talked about how our goal was to not make it so broad. The first draft was kind of broad, and I see some places where I think one could still interpret it pretty broadly and maybe not be too perfectly assured that one's information that Reddit has about you isn't going to be turned over to a third party. Particularly paragraph 15 says, and I'm paraphrasing because I don't want to just parse the actual language, but I read paragraph 15 of the new privacy policy to really give Reddit the power to turn over information it has about you based on if it has a reasonable belief that it's answering a legal request. So what does that mean? If a lawyer writes Reddit an answer and says, there's pending litigation against so-and-so, turn over all the information you have, I could read paragraph 15 to say that Reddit would be fine in turning it over in that type of situation. I don't know if that's what's intended, but I see it written that way. I guess one of the good things about Reddit is you can sign up and really meaningfully participate, even without turning over much information about yourself, especially if you're going to use a proxy server or whatever to obfuscate your IP. You don't have to sign up with an email address. You don't really have to do any sort of authentication. It's very easy to sign up for a throwaway user identity on that. So, maybe that's the real consolation in all this is, what does Reddit really know about you anyway? At the same time, I think people are pretty revealing about themselves on Reddit because they know that it's so easy to set an account up and that there is essentially no authentication that goes into it. So, it's never a bad thing to try to make something simpler and to more perfectly tailor it to something, but like all human endeavors, it's imperfect in this situation.
Right. Well, it goes into effect on May 15th, and we'll just have to see if it makes our resource of the week from last week, EFF's Who's Got Your Back list, because it seems like Reddit might want to be on that list. What were you going to say, Polk?
I was just going to observe that companies in the online space are really in a form of a no-win situation with regards to these sorts of policies, which is, on the one hand, you don't want to write a policy that's overly broad. Your users will get upset and so forth. On the other hand, you have to write a policy that's adaptable enough to things that you don't know that are going to happen. You don't know exactly what kind of requests are going to come in that you're going to need to respond to or essentially be forced to respond to. And you need to be able to write a policy that you're pretty sure your company can actually follow. It'd be great to write a policy that's, super protective of privacy, but if your company isn't going to be able to follow it, you're worse off than having no policy at all. So I just want to be sort of sympathetic to companies who are trying to do the right thing in these areas by putting down a policy that reflects what they actually do, being very clear to their users about what it is that their plans are and what the parameters are, but also, recognizing that there are some things that they can't predict. And what lawyers do is try and build in language that allows for changing conditions.
Yeah.
All right. Well, go ahead, Julie.
Sorry, I just wanted to agree with that, and also it just seems to raise another, the issue that like the idea of writing a policy to be simple and things that your users can actually read and understand, but then at the same time, is quickly and easily criticized for being too general and not specific enough, and to be able to, drill down in those ways, maybe those, it's almost mutually exclusive to be able to write it that way and to do all the things that Polk just said are important when writing a policy like this. So I think it just shows the struggles, but, really applaud them for the effort and for being willing to take their users' comments and they're going to revise the policy and, work it into changing it. So I think they're showing some real leadership on how these policies can be drafted.
Well, there are a couple of other things I want to discuss, but if we can agree to discuss them quickly, because we're closing in on our end time for the show. They're both too nice not to get to, I think, or I'm personally interested in both of them anyway. Evan, over on Internet Cases, you wrote up something interesting about a court not being able to exercise personal jurisdiction over someone because the business had a Facebook page. That seems to be a reasonable approach and important when everybody and their business has a Facebook page, that it would take something more than just that to establish personal jurisdiction in a particular location. So we're headed in a good direction there?
Well, I guess so. I mean, it's that the direction is set out for us, by the Supreme Court, 25, 30 years ago in the Calder test, the Calder effects test that we learn about in the first week of civil procedure in law school. What made this case interesting, and just briefly talking about the facts here, it was a bar in a border, or in a town on the Illinois-Iowa border. It was in Illinois, and an Iowa resident came across the border and got shot at the bar, and then sued the bar in an Iowa court, just literally right across the river. And the Illinois bar tavern moved to dismiss for lack of personal jurisdiction. They said that, oh, well, you've got this Facebook page, you're going to be marketing to everybody here, and there's no reason to think that somebody just right across the border in Iowa, just a few miles away, is going to not see this content here. So, the way that the facts played out here, there wasn't enough to meet this threshold that's, at this portion of the analysis to show that they did anything to expressly target trying to get customers to cross the border into Illinois to come drinking at their place, which, is kind of an interesting thing, because it's in this scenario, really, the fact that the state line was there is really pretty arbitrary, because we know how towns are on state lines. People come from just all around, and they don't necessarily think about when they're crossing the state line on all this. So what it does for us is just let us know that courts are not so willing to look at the interactive nature of a Facebook page. If a court were to purely apply like the Zippo test, that famous Eastern District of Pennsylvania case from 1997 that talks about, the sliding scale interactivity test of how interactive the website is to confer jurisdiction. It looks like they're not necessarily willing to just look at that as the be all and end all test. There really has to be something more that is meant by purposely directing one's content through social media into a foreign jurisdiction. So even though personal jurisdiction is a pretty elementary idea, when it comes to these things, social media continues to allow courts to add nuance to the analysis. And this one was particularly interesting because it happened to involve a border town.
All right. Well, thanks for the update on that. Polk, why don't you update us on MOOCs?
On MOOCs, well, so MOOCs are growing, obviously, leaps and bounds in terms of their significance and potentially their importance, although I think we don't really know yet where they're going to end up in terms of their importance. There's been, I think, increasingly a controversy among at least some faculties around the country, not necessarily law faculties, but other faculties, about how their schools, how their universities are going to deal with MOOCs. And I think those are...
Can I jump in and define the acronym real quick? Massive
Sure.
Open Online Courses.
Yeah.
So
these
alternatives
courses,
to traditional education.
right. So these courses are ones that are offered online and are often massive in that they tend to get large numbers of students from all over the world to sign up for them. There's many commercial providers in this space already. There's a lot of universities who are both partnering up with commercial providers as well as doing their own thing. And I think it's an area that's in enormous growth phase and a lot of upheaval, and nobody really knows where it's going to go. The issue that has arisen a couple of times over the last couple of weeks is that various faculties have expressed their concern. In particular, this week there was a faculty concern at San Jose State about whether or not the MOOCs from other universities' professors are going to be used as components of the curriculum in their university. And there's also a number of controversies at different universities about, what are the responsibilities of traditional faculty members in terms of teaching these MOOCs? How is that part of your normal teaching duties? Is that something additional? Who has the rights to the MOOCs? These are all issues that are having to be sorted through right now. And I think that, this is an area that we're going to be watching for a long time.
Okay, thank you for that. We have a tip and a resource to get out to you. The tip has to do with sort of in the wake of all of our discussions and examinations of the Computer Fraud and Abuse Act, and we alluded to Aaron's Law drafted by Representative Lofgren that's pending now. So if you're at sea about how you can legally hack, why not go to the NSA as your touchstone for what's legal or not? This was written up over at Threat Level by Kim Zetter there. There was a FOIA request that revealed something authored by the NSA called Untangling the Web, a guide to internet research that has a whole section on Google hacking and finding publicly available information that was not intended to be on the web. Now, people like Andrew Weave Orenheimer are facing charges and sentencing on these kinds of activities. But at least, there's language in this NSA book that says, now, we're not advocating doing anything illegal. Nothing I am going to describe to you is illegal, nor does it in any way involve accessing unauthorized data, the author says. So, if you're looking for something to buttress your activities, this might be something to take a look at. Not bad to throw the NSA's own guide and language into a discussion on this point, I would think. Finally, a resource of the week that is pretty interesting via Mary Hodder and Customer Commons. They did a survey on the percentage of individuals who employ dodges and fake information when they're asked for personal information online. And it calls into question, how accurate big data actually is, because if people are being careful about that to hide their actual personal information, then, how good can the data really be? So Mary's comment on that is it's an illusion of control because the trackers, fingerprinting, beacons, et cetera, data aggregators are still able to aggregate us, but it probably means they have a lot of bad data associated with our dossiers. So if you want to go read Lying and Hiding in the Name of Privacy, Mary and Customer Commons have a lot of information there on that subject. So, guys, this has been a really, really fun show. Very interesting. We've covered a lot of ground. Julie, great to meet you.
Great to meet you, too. Thanks again for having me. It's been fun.
Our pleasure. Keep us posted on what happens with the Ravens and your other activities. Folks can keep up with those activities over on your blog at CIS. Is that right?
Yes, that's right.
Okay, so we'll continue to do that. Thanks so much for joining us on the show. When I invited you, you said you were a listener, and I just can't tell you how happy that makes me. So that's
I was happy to hear from you.
Yes. Great. So we will touch base with you soon again, I hope. Is there anything you want to plug before we sign off today?
Oh, sure. We're having a 3D printing lunch event for those in the Bay Area here at Stanford on Thursday. 3D printing is the law ready for the future is the name of the discussion, and that's going to also include a 3D printing demo. So that should be pretty fun, and that's this Thursday at 12:50 p.m. And you can find more information about that at the CIS website.
That's awesome. And the way you said it, it sounded like you might be 3D printing the lunch itself, which would be fascinating.
Cool. All in good time.
I would sign up for that. Polk, wonderful meeting you too. Thanks so much for joining us.
Thank you. I was really happy to be invited and enjoyed it very much.
Wonderful. And work on your hoops game. We're going to expect you to defeat the students next year.
We'll try. We get a little better every year.
All right, good. Anything you want to let us know going on in your neck of the woods?
So if you're local to Philadelphia, you should definitely, direct message me on Twitter to get on our email list for the Penn Center for Internet Technology and Competition. We have a lot of events that go on all year round that are publicly open to the public to get involved in. I have a course on Coursera that's coming out in the fall on introduction to intellectual property, and hope probably some of your listeners would be interested in that.
Very cool. I'm sure a lot of them will be. Hey, Evan, this has been great.
For
so
sure.
good to talk with you.
Yes, the same. Yeah, I've really enjoyed talking with our guests as well. Polk, really nice to meet you, and Julie, same. Like I said, really interested in the work you're doing some great stuff out there at CIS. Some stuff that really, will have impact for many years, not just some sort of ephemera. It's very meaningful. So really have enjoyed our conversation. Glad we could talk.
Great. Thanks, guys. Me too.
Thanks.
All right. So we do the show every Friday at 11 o'clock Pacific time, 1800 UTC. You can tune in at twit.tv and join us live. Jump in the IRC if you do that, and we'll have the full interactive show experience. But if you can't do that, you can watch us on demand as well. The whole archive of shows is at twit.tv/twill. We're on YouTube. We're in iTunes. However you would like to pull us up, we're going to be there for you. And we're just happy to have you join us however you can. Between the shows, please join us over in social media one way or the other. Evan and I are on Twitter. I'm D. Howell. He's Internet Cases. We have a Facebook page and a Google Plus page for the show where we put up topics during the week, and we love to hear from you in all of those forums. So we have some ideas what you want to hear about on the show. We get great tips and pointers from our audience, and we really, really appreciate that. And I think we'll end this show with my own this is now going to fix it in a medium. So now it's a copyrighted work that is not going to infringe copyright like the Happy Birthday song can. This is our family's little birthday song for Franklin. Franklin, you're now an official member of the family because I'm going to sing to you today is your birthday. Today is your birthday. Not the apple or the bear, not the monkey or the pear, but today is your birthday. And yes, no, I know that doesn't make any sense whatsoever, but that's what we sing on people's birthdays. Hope you enjoyed that, and we're just thrilled that you've joined us for This Week in Law. We'll see you next week. Take care.